Hello and welcome to Media News. Media News aims to be an authentic voice bringing you real, truthful stories from the Middle East, with a particular focus on the Kurdish question that is often ignored, self-censored or suppressed by the mainstream media platforms. In today's edition of our podcast, we will be looking at the now famous Belgian court case that concluded at the beginning of last year after a long and protracted fight in the Belgian courts that the PKK were not, as of course our listeners and followers of Media News will know already, a terrorist organization, but rather a party to an armed conflict with Turkey going back many decades. And to hear about the case firsthand, we are very honored to be joined by the lawyer who led the case, Jan Fermon. Jan is a lawyer and independent legal practitioner at the Bar of Brussels in Belgium and is specialized in international criminal law and is presently the Secretary General of the International Association of Democratic Lawyers. In January 2020, after a 10-year legal wrangle, which was brought against 40 Kurdish individuals and 2 media organizations, the Belgian Court of Cassation confirmed a decision by the Brussels Court of Appeal that the PKK, the Kurdistan Workers' Party in Turkey, should not be classified as a terrorist organization. The ruling by the court, in fact Belgium's Supreme Court, states that EU anti-terrorism legislation cannot be applied against the PKK since it is a party in a non-international armed conflict or civil war where the use of legitimate military force is allowed under international law. Of course, as we have discussed in previous podcasts on this issue with Dr. Lucas Thun, a lawyer based in Germany, and Alistair Lyon, a lawyer based in the UK, the labeling of the legitimate self-defense struggle of the Kurds for basic human and political rights in Turkey against a backdrop of a policy of forced assimilation, racism, and genocidal policies is, of course, a political action rather than anything to do with international law. The Belgium case, which began in 2009, also exposes the magnitude of these political attempts, firstly by Turkey, but then joined by the US authorities, to try and forcibly pin this insidious terrorist label that is used solely to justify further repression of the Kurds and democracy in Turkey, and that has inflicted indescribable and incalculable brutality and trauma on millions of Kurdish people, might never have seen the light of day were it not for the Julian Assange and the WikiLeaks, who detailed and exposed all the dirty dealings of those involved, and which Jan, I'm sure, will refer to in his introduction. Although this case was not directly about the PKK's inclusion on a prescribed list by different countries, but rather a criminal prosecution brought by the Belgian federal prosecutor for participation in the activity of an alleged terrorist organization, the PKK in this case, the case is historic and extraordinary as it comprehensively, over a period of 10 years, fully exposes the complicity of various states to aid Turkey in their brutal war against the Kurds, and has now given inspiration, renewed energy and motivation to the Kurds and pro-Kurdish rights campaigners in the struggle to finally remove the PKK from all lists of prescribed organizations, which would hopefully then open a road and a possibility of an alternative approach, a peaceful and a political solution to the Kurdish issue that is screaming out for a solution. So, Jan, welcome to Media News. There may be some people listening who do not know about the Belgium case, or who might have heard about the case, but do not know the details. Would you be so kind as to give us a brief overview of the Belgium case that comprehensively decriminalized the PKK and exposed the political nature of the case in all of Belgium's courts over a period of 10 years, and is now being used in legal arguments in other legal cases all over Europe and further afield to widen the struggle for complete decriminalization of the PKK and to open the possibility of a political solution to the Kurdish question in the Middle East. Welcome, Jan, again, and please, the floor is yours.
Thank you, Mark. Actually, you in your introduction, of course, you said already you gave a lot of information about the Belgian case. But maybe I would like to start with this. You said it has been an ongoing struggle for 10 years. You are right, the case started now a little bit more than 10 years ago. But actually the whole issue started in 1996. In 1996, the Belgian chief of police concluded an agreement with the head of the Turkish police and with the then infamous Minister of Interior, Mehmet Agar, for cooperation in matters of terrorism. That was an agreement that was discovered by chance, and I also played a role in this because actually I discovered it because I was flying from Istanbul to Brussels after a delegation, participating in a delegation trial observation in Diyarbakir. And I was reading Turkish Daily News, which was a newspaper which was then freely distributed in the airplane. And I read actually in Turkish Daily News about this agreement. Nobody knew about it in Belgium. It was in August, I think it was in August 1996. There were some, when I came back to the country, of course, I spoke to some journalists asked questions, and then we had this very strange situation where questions in Parliament were asked, and the Minister of Interior of that time said, no, it's not a cooperation agreement, it's a memorandum, it's a protocol, and actually what happened is that the Belgian police chief was on holiday in Turkey and met by chance the Turkish police chief. So they were both lying at the beach somewhere, and one said, what are you doing in life? And he said, oh, I'm the police chief. And the other one said, oh, yes, I'm not. So we had all this nonsense about this agreement. In September of that year, there was a major raid on the studios and the offices of MedTV, which at that time, there was no anti-terrorist legislation in Belgium, but there was a major raid by the police and a case which was started for money laundering and all kinds of accusations of this time. Criminal organization, money laundering, etc. That case collapsed in, I think it was 2002, because we were able to show that the prosecution was actually using false anonymous witnesses. And it's a long story, I'm not going to go into that, but the case went on for 35 full-day hearings when finally we discovered this and it collapsed completely. Belgian authorities then tried to actually launch a tax case against Kurdish television, against Rosh TV, because a lot of money had been seized in the first case, money that was to be used for buying the satellite license for Rosh TV at that time. And so the Belgian authorities then started a tax case. And there were actually some debates in Parliament saying that they were going to use this money to actually close the gap in the budget, because it was a lot of money. They were going to close the gap in the budget thanks to this money, which was almost as ridiculous as the debate on the two policemen on the beach. Then that case also collapsed because the tax court actually found that there was nothing wrong with this money and that therefore there was no reason to keep it, that there was no reason that the Belgian tax authorities could keep it. And that is approximately in 2006. And that is where WikiLeaks starts. That is where the rest of the story starts, where we can see where the roots of the present case were. When this tax case collapsed, Turkish officials came to Belgium, trying to press the Belgian authorities to launch a new case against the Kurdish media outlets in Belgium, but also against some individuals, the representatives of the Kurdish National Congress in Brussels and other Kurdish organizations. And from WikiLeaks, we can read in WikiLeaks that in the beginning, the Belgian officials, essentially foreign ministry officials, told the Turkish that on the basis of what they presented as so-called evidence, it was totally impossible to make a case, because actually they were presenting documents regarding speeches and public positions of some of the Kurdish prominent leaders that are present in Brussels, and some analysis from broadcastings from the media outlets. But the Belgians said, this is, sorry, but there's nothing wrong with this. This is, as far as Belgium is concerned, this is freedom of expression. The Turks were not happy about that. The Turkish authorities were not happy about that. And so they did what any kid who is in a fight and who can't win the fight will do. They got their big brother. So they turned to the US Embassy, who then started organizing meetings where they actually called both the Turkish diplomatic representatives in Belgium and some Belgian authorities. And the Belgian authorities actually repeated what they said previously. There is no case. But the Americans became very insistent. Actually, 3 high-level delegations were sent to Belgium. Very top-level US delegations came to Belgium to discuss with the Belgian authorities. The Belgian, 3 Belgian ministers were invited to Ankara to discuss the matter. And also the Belgian, the American embassy discussed the matter separately with the then federal prosecutor, whom we know was in close cooperation with Turkey already before. And this federal prosecutor at some point said, but I have an idea. I have a case about some money, suspicious money in a cultural association in Charleroi. I have a file somewhere about a women's camp in the east of Belgium, near the, women's camp. And if you look in what is the content of that camp, women gathered, sang together songs, exchanged, discussed politics, and of course the police went there to find out what was going on, and they made an information report. So there was formally some kind of file, and the federal prosecutor said, I will gather all this together in one big file. I will then say that on top of this, that all this activity in Belgium is controlled by PKK, and that therefore all this activity is participation in the activity of a terrorist organization. And that's the way how this case actually started. The federal prosecutor then asked an investigating judge, because you have to know that in Belgium the system is very similar to the French system, where an investigating judge is leading the investigation and is in charge of it, and the prosecutor has to request to this investigating judge some, for example, arrest warrants or search warrants. The investigating judge was then asked to issue arrest warrants, which he did, and some people were arrested. But very, very quickly, we also felt that the Belgian judicial authorities were not necessarily on the same line, didn't necessarily agree to what was happening. Because these so-called terrorist leaders, Remzi Kartal, Zubair Haidar, who were considered to be the main representatives of PKK in Europe, etc., they were arrested, and then after 5 days they have to be heard by a judge, and after 5 days the judge said, okay, well, we'll keep them for a while, but after 15 days the appeal court goes again, examines it again, and after 15 days the appeal court says, no, let them go. nothing there, please. Nevertheless, that resulted in 10 years. Then the judge, of course, did what he did his job. Huh? He did conducted an investigation, made search operations, etc., which was, I think, annoying but inevitable. And it became rather clear that the investigating judge was not really on the same position as the federal prosecutor. Because we had a good contact with the judge, and he conducted a very good investigation. At the end of the investigation, when it was concluded in, I think we are then 2015 or 2016, a kind of preliminary court, has to decide whether the case will go to a trial court, yes or no. In that preliminary court, the investigating judge makes a report. So he reports on everything he did, because it's another judge who then has to decide whether the case will go on, yes or no. And we actually all prepared for a very long report, because there were tens and tens of search operations and phone taps, etc. And normally the judge will give a more or less detailed overview of what he did and what were the results of each action he took. Instead of that, the judge, the investigating judge, came into the room and said, Your Honor, to the president of the court, when I started this investigation, I was told, which means the prosecutor told me, because nobody else could have told me, I was told that these people, pointing at Remzi Kartal and Zubair Haidar, who were on the front row, were very, very, very bad people, very nasty people. But after conducting my investigation, I think they might also be freedom fighters. And actually, with what is happening now in the Middle East, I'm not quite sure what we are doing here. Thank you very much. End of my report.
Wow.
And the prosecutor spontaneously, without, almost without thinking, I think, said, "Oh, I see I'm alone here." And that was actually indeed the beginning of the story. We then raised the question, which in the beginning we thought would be difficult to argue, not because from a legal point of view it was not correct, but nevertheless it's such a principled stand that we thought the court would find it difficult to follow us. We hoped that the court maybe instead of taking very principled stand, would find some other way to evacuate the case. But of course we raised the question. The question we raised is that in all anti-terrorist international instruments, all treaties on anti-terrorism, and also in the European instruments, the directive on combating terrorism, as well as in the Belgian law, but we actually didn't need the Belgian law because it's in the international instruments anyhow, and I think that's important for the discussion about how can we use this case later to do something in different countries. There's a clause saying that anti-terrorist law cannot apply to parties in an armed conflict. And that is logical. That's logical because for a series of reasons. Actually, that provision was first introduced in a treaty negotiated in the 1990s on the use of explosives for terrorist actions. And actually, Belgium at that time already, in the negotiation on this treaty, said, okay, if we criminalize as a terrorist act any use of explosives, then it means that actually our armed forces, when they conduct war, when they are involved in an armed conflict, are committing terrorist crimes all the time. Because of course we use bombs, and of course we use grenades in such a conflict. And so we have to find some way to to avoid that our own armed forces are under this anti-terrorism. They came up with a proposal. Some of the participants in the negotiation came up with a proposal saying, okay, let's put in the treaty that armed state forces, that this is not applicable to armed state forces. But that raised another problem. Because if you have an armed conflict between state forces and non-state forces, like, for example, the armed struggle in South Africa during the apartheid, or many other situations where you have civil war in a country, then it means that actually, if you don't exclude both from the application of anti-terrorism law, then you weigh on the conflict on the side of the state forces, who can never be considered to use or to commit terrorist offenses, but everything the non-state force would do would be a terrorist offense. And so, again, Belgium, but also other countries, and especially the Committee of the International Red Cross, intervened to say, no, this is impossible. We have to exclude all armed forces in a conflict. Not only the state forces, but also non-state actors in a non-international armed conflict. And so that's how the provision got into all treaties regarding terrorism, into the European instruments regarding terrorism, and into the Belgian law. But actually, as I said, we didn't need that. It was an easy step for us to use the Belgian law, because then you didn't have any discussion about whether international law applied and to what extent, yes or no. But even if it was not in the Belgian law, I think the situation would have been the same. And so we started arguing that the conflict between Turkey and the Kurds was a non-international armed conflict. In order to decide whether a conflict is actually a civil war, and then the laws of war apply, not anti-terrorism law, there are two criteria. First criterion is the intensity of the conflict. And the second criterion is the degree of organization of the non-state actor, which means it should be really a war and not just some fighting or some isolated incidents. And two, the non-state actor should have the capacity to conduct as an army, not just as a group, disorganized group. So we suddenly then got into a discussion about the intensity of the conflict, where the prosecution had some very strange arguments. For example, they said that there were no displaced persons, that the intensity of the conflict was not intense because there was no displaced persons. Which was very strange, because we actually then came up with studies from the Istanbul University saying that there were 1 to 2 million displaced persons, and also amnesty and the prosecution at some point came up with the point that PKK did not have trucks to transport its troops, and therefore was not to be considered as an organized. And we said, well, it's a little bit strange argument, because as far as we know, in Dien Bien Phu, the Vietnamese carried their weapons up the hills on their backs, and nobody is crazy enough to say that this is not an armed conflict. We also in a very detailed way showed that the HPG, the armed forces, Kurdish armed forces, were an organized force that could conduct coordinated operations on a large territory. And so actually the prosecution there was, I think, rather weak in its arguments. Not because they didn't do their work well, but simply because the situation was not in their favor.
Jan, thank you for that. One of the really interesting aspects of the case that when I listened to you talking about this case before was the quality of the evidence that, I mean, I believe that Turkey wasn't actually allowed to be they were actually a civil party to the case, weren't they? And so they were allowed to bring their so-called evidence in their view, proving that that the PKK was a terrorist organization, which I believe wasn't fantastically strong evidence. Could you tell us a little bit about that?
No, you're absolutely right. The Turkish state was a civil party, and under the Belgian legal system, a civil party can fully discuss the matters of guilt. They can't discuss in the courts, but they can discuss the matter of guilt, and so bring evidence and submit evidence to the court. Now, both actually the Turkish state and the prosecution brought a series of lists of events which we analyzed in detail. It was actually that list that was also submitted and used to list PKK on a European level, which is interesting, I think, because it makes a link with the listing on the European level. And we found out that a lot of these so-called attacks committed by PKK were actually events that were unsolved, at least, or in some of the cases were even clearly false flag actions, to the point that in some of these events, even Turkish courts had already taken a decision either acquitting people that were initially charged with these cases and related to PKK, or even convicting some others, even members of the security apparatus, which is rather, I would say, if even a Turkish court finds that this is not an action of PKK, then it goes very far, of course. But I think basically the Turkish civil party, the Turkish state, never went beyond submitting a list of events. And so that gives us it was actually an advantage that they were in the courtroom, because in many occasions we turned to them and we said, well, you are not a failed state, or at least we think you're not a failed state. So, which means that when a bomb explodes in, let's say, Ankara or Istanbul or in another place, you conduct an investigation, like any other country, normal country would do so. You tap phones, you try to identify the components of the bomb, you try to identify the explosives that were used and to trace those components and explosives. You interrogate suspects, etc. Where is all this material? Why don't you submit to the Belgian court these materials? Because if indeed you have materials showing that these attacks, which were not actually, the HPG did not declare itself responsible for these attacks. If you think PKK is responsible for these attacks, you should have some evidence in your file. Why don't you submit this to the Belgian court? And then the lawyer of the Turkish state was very embarrassed about this request, looked at his shoes, tried to hide under the table, because he didn't have anything. And he knew it was a pertinent question. It was a relevant question. And so I think that also contributed to the fact that the court got convinced that many of the allegations were actually completely false and just propaganda to try to make PKK responsible. And what was left at the end of this list, what was really left, were acts of war. It's an attack on a military compound. It's an attack on a military convoy, which are acts of war and should be judged or should be assessed under the laws of war, not under the anti-terrorist laws. And so I think this also contributed, the attitude of the Turkish state also contributed to the fact that the court understood that this was not about terrorism, but that this was about the civil war, where the Turkish authorities really misconducted. And so I think that's one of the reasons the court went back to the position which was traditionally rather the Belgian position, which was if you don't import your civil war into our country, in which case we will defend ourselves. But if you don't import your war into our society, then you can speak out freely, you can benefit from freedom of speech and freedom of organization. And that actually is that is the result of the court decision, because finally the court dismissed the whole case, this preliminary court dismissed the whole case, saying that PKK was party to an armed conflict, and therefore the law, anti-terrorist laws, does not apply to PKK.
And then, of course, it was appealed, and then it went right the way up to the top and the Supreme Court. So it's very comprehensively dealt with in every single angle.
The decision is really final. The prosecution appealed it first in the Supreme Court, and then on a procedural detail, actually, the decision was quashed. It went to another chambers of the appeal court, who heard the case again and came to the same conclusion. The prosecution appealed it again in the Supreme Court, and then the Supreme Court simply confirmed this last decision of the appeals court, which means that it's now final.
It is one of the, the first times, really. I mean, since I've been campaigning on the Kurdish issue for 28 years, I've come across all these false flag operations of Kurds being murdered in minibuses and then saying it was the PKK and sending delegations and actually finding out it was the Turkish state that carried out all these. So this criminalization aspect is such a barrier and an obstacle for a peaceful solution for the Kurdish issue. After the result was announced, Orhan Kilic, spokesperson of the Council of the Kurdish Community in Belgium, said that this is a unique event and will have consequences for other countries and even the European Union. This sets new standards in debates on the Kurdish issue, the action of the Turkish state, and the role of the PKK. We hope that with this decriminalization, Western governments and the EU will be better positioned to force Turkey to seek a peaceful and political solution to the Kurdish question. I know I've heard you mention also that there is another case around freezing of assets that is ongoing from some of your Dutch colleagues. Is that case still ongoing in the European courts?
That case, first of all, is distinct from the case in Belgium because it's not about criminal law. It's a case against the EU listing, which is actually an act of the executive. It's not a criminal prosecution. The listing is decided by the governments, the EU governments, working together in the EU Council. And so the case was brought. This listing is actually a process where every 6 months the European Union takes a new decision, listing again or maintaining on the list organizations and individuals. And so the case was brought against the listings from 2014 on. The Court of First Instance of the European Union in Luxembourg, in a first decision, said that actually the PKK, that the statement of reasons to include PKK in the list of terrorist organizations was insufficient. And they cancelled all the inclusions until between 2014 and 2018. However, in the very last stage of the trial, when it was not possible anymore to include the last decision in the proceedings, the European Union took a new decision. And so the court cancelled all inclusions in the list between 2014 and 2018, but could not include for procedural reasons the very last one in 2018, which stood, and a new case was brought against that and is still pending. But in the meanwhile also, the Council of the European Union appealed the decision of the Court of First Instance, and the case went then to the Court of Justice, which is actually the appeal degree in the European Union. The Court of Justice cancelled the decision of the Court of First Instance on actually what I consider to be a technicality, because they said it's actually not a problem of statement of reasons, it's a problem of legality of the organization which you raise. If there is insufficient evidence to consider an organization as a terrorist organization, then this is a matter of legality of the decision, not of statement of reasons. And so, I mean, that is legal technical discussion. But so now the case went back to the Court of First Instance because the first decision was cancelled and the case was referred again to the Court of First Instance, who will have to take a new decision. But I think from a political point of view, what we can retain from this is that the Court of First Instance of the European Union at least found in its first decision that there were no sufficient reasons to include PKK in the list of terrorist organizations, at least between 2014 and 2018, because the evidence, the so-called evidence that was submitted to, or that was used by the European Council to, on the basis of which it took its decision, was actually also part of the evidence that was used in the Belgian trial, including the list with all the false flag actions and the unsolved cases in Turkey. So I think logically, but you never know with the European Court, of course, but logically we should get a similar decision saying that the evidence to consider PKK as a terrorist organization on which the European Union based its decision is insufficient to support that decision. And I hope that decision will come in the next weeks or months.
Jan, you have had such a lot of experience in terms of all of these issues and international law, and you've been following the Kurdish issue for such a long time. Do you personally have a feeling that the winds are changing, that there is a different political climate, perhaps because of the deteriorating relationship between America, US-Turkey relations, and the increasing pressure that the European Court of Human Rights and the Council of Ministers, indeed, today are supposed to be deciding upon a case of Demirtas and Kavala and Öcalan. But there's supposed to be a result about that today. Do you feel that there is this changing winds? And what advice would you have for Kurds and pro-Kurdish campaigners who are campaigning on the issue of decriminalization? I take a great deal of inspiration and motivation from the Belgium court case. And in that regard, it has shown and has exposed the political nature of the decriminalization. What advice would you be giving us as campaigners, as the Kurdish movement, to push further for delisting, to try and get rid of this insidious label once and for all?
First of all, I would like to say that my conclusion from the Belgian cases, including the previous case on Kurdish television, which I mentioned in the beginning of my intervention, shows that there is no monolithic bloc on the other side. In every country, in the judiciary, in the political spheres, there is, I would say, both forces who have a reasonable, good approach to this, who think that this problem should be solved, and not by criminalizing one party, but by pushing both parties to discuss and to negotiate. And there are other forces at the same time at work who are 100% on the criminalization line. And I think the experience we have in Belgium with the Roche TV case, and then subsequently, and now also with the case in the European Court, shows that both these tendencies or both these approaches are present in different European countries. Of course, the climate now is better for those who want a reasonable approach and who want to put an end to the criminalization of the Kurds. The climate is, of course, better because after the fight against ISIS and other, it's very obvious that the attitude towards the Kurds, also in public opinion to a certain extent, has changed. So I would say there is a window of opportunities now, which is clear, which we have to seize. The other point I would like to say is that, very frankly, both when we started the Roche TV case in 1996 and when we started this case in 2009, and especially when it came to the end of the investigation and we started arguing about the point which finally we won, we hardly believed that this would succeed. we were very pessimistic ourselves, because I think we were influenced by the experience from the past, that the criminalization is a kind of process which goes on and on and on, and whatever you say, it doesn't mind. Anyhow, criminalization will go on. And so I think what we should learn from this experience is that we should exploit fully the cracks on the other side. We should do whatever is possible and continue to try to widen the cracks in the opposite side. And then, if we, I would say, continue to do this, then it is possible to push back the criminalization. It is possible. It's not going to be in a simple process, and it's not because we have a good decision now in Belgium that everywhere things will change throughout Europe, etc. It's very clear that that is not going to happen. But at least we have one step forward, which we can use, like going up steps to try to at least bring some of it to other countries and other jurisdictions, and to try to stop gradually the process of, and we have to continue to believe that that is possible, because the practice shows that it's possible. So I think that's the main lesson I think the Kurdish solidarity movement and our Kurdish friends could draw from this experience. It's you have to fight and continue fighting, and at some point we will succeed to have successes in that fight.
Well, that's a very positive and optimistic note to finish this interview, Jan. And you have certainly made a very historic and significant contribution to that path. And I would like to thank you, from many people watching and listening to this program, from the bottom of our hearts. You've given us the ability to be able to do that now. And I know this is being now argued in courts all over the world. And let's hope that we are able to push the door open a little bit more, as you say. So thank you very much for talking to us about these issues. And we hope to speak to you again in the not too distant future. Jan Fermon, lead lawyer of the historic Belgium court case that went a long way on the journey to decriminalize the PKK. Thank you very much for joining me. Thank you very much, Jan. Thank you.
Bye-bye.
Bye-bye. Bye-bye.